So welcome to this presentation. We have Cindy here with us. Cindy has a law practice in Walnut Creek. She does probate and estate planning. So Cindy is an active member of the Contra Costa Bar Association and part of the Trust and Estates section. She is also very involved in her local community, volunteers on the steering committee of La Miranda Moms, and spends her free time with her husband and 2 boys. Even with a very busy practice, Cindy is very generous with her time and expertise with cancer support community. She's on the member of our Legacy Advisory Council, which is 12 professionals who are attorneys and financial advisors who provide their knowledge and their experiences as a resource for cancer support community. In addition to being on that council and doing this presentation, Cindy has done speed consulting with cancer support community in the past. And we're grateful for all she brings to the community.
Everybody, good morning. Thanks for joining me and your interest in my topic today. I am going to talk about a specific case that I've dealt with as far as an estate planning client who passed away, and we had to deal with all sorts of hiccups along the way, managing his estate. But I want everybody to feel free to interrupt me with questions. If there's words that I'm using that you don't understand or you want clarity, feel free to jump in. This is meant to be an interactive discussion so that you can actually relate what I'm talking to, the points that I'm talking about, to your own situation in your life. So I'm gonna use a PowerPoint just to drive us along with all the facts and information, and hopefully that will work. So I'm going to try to do that now. There we go. Okay. So can everybody see okay? Give me a thumbs up or a shake or a head or something if you can't see the PowerPoint.
Looks good.
We got it.
Great. So again, as Andy mentioned, I'm a local attorney here in Walnut Creek, and I've done a lot of activities with cancer support community. One of my favorite things to do is to go out into our community and educate people on estate planning and help them with their specific questions as it pertains to setting up their trust and wills and understanding why you might need a trust versus a will, what a probate is, and how to best help people with planning for their family. Certainly, people at the Cancer Support Community Center group can understand why this is important, because you're actually facing real situations where your health is in jeopardy potentially, and you want to make sure that you're leaving your legacy the way that you want it to be. So we're going to talk about a specific case, as I mentioned, that I dealt with recently, and obviously I've changed lots of facts and details so that it's not an easily identifiable matter, but it's kind of funny to call it the soap opera or just another case in probate, because a lot of the times my cases do sound really crazy, like there's some sort of a soap opera going on. How could this possibly be real life? But it is, and we deal with all sorts of crazy scenarios that start from a family that just seems really simple and straightforward. So I will launch into that now. This is the client that we're going to call him Jack. And to tell you a little bit about Jack, he is a junior, so Jack Smith Jr. He was the son of Jack and Mary. And over his lifetime, Jack was married 3 different times. He had 2 children with his wife, Leonore, and then he had no children with Betty and Abby, but he was divorced from them. That's important to know, just because sometimes there can be community property interests, even if you're divorced from somebody. Jack had Daniel and Sally with his wife, Leonore, and Leonore passed away. So obviously Jack was widowed and after that married Betty. But what's important to know here is that from his marriage with Leonore, he had 2 kids, Daniel and Sally. Later, we discovered that that Jack, in fact, had a third child, Jeffrey. Jeffrey was not from his marriage to Leonore. He was raised by his mother and his stepfather, and he had no relationship with Jack. They didn't really connect until adulthood. And honestly, we still don't even really know if Jack was aware of Jeffrey's existence when he was a child, or if there was just rumors about it. And then as an adult, Jeffrey and Jack made contact and developed a relationship, which was great because it was important to both of them. So just to give you a sense here, this picture is kind of just to give you an idea of what we deal with a lot in estate planning is complex blended marriages, children, cousins, siblings who come out of the woodwork down the road. And of course, people's partners pass away and people subsequently get married or people get divorced. And there's a lot to think about. And so all that impacts how an estate is distributed upon one's death. So Jack came to see me in February of 2020. He was diagnosed with pancreatic cancer and was very sick. He was in a terminal. Oh, is someone speaking? Did I hear somebody? No, okay. So he was very sick and terminal with pancreatic cancer, and he knew that he wanted to get his estate plan set up because he knew that he had assets. He knew that he wanted them to pass to certain people, and he fortunately knew that he didn't want his estate to go through probate. So just a reminder for those who may or may not know, when you have a trust set up, that's really what you use in order to avoid probate. So if you don't want your estate going through the court process of administering it and having everything distributed through court, you can set up a trust, and the trust circumvents or avoids that process by simply saying, here's who I want in charge, the trustee, here's what I have, and here's who I want it to go to. So if I have all of my assets in a trust, then I don't need to go to probate. I don't need to go to court and figure out what the assets are and who's in charge and who gets what. I save my family tens of thousands of dollars. I save my family lots of time, and they simply go through the trust. So Jack knew that he had assets. He knew obviously that he had children and family that he wanted to plan for, and he knew that he wasn't well. And so he came to see me and said, I want to get my estate plan in place and take care of my family. Even though he was really ill, he had full mental capacity and was very clear on what he wanted to happen. Obviously, having capacity is critical for setting up an estate plan. Someone else can't set it up on your behalf. So it's important that you come to see the attorney and make the decisions yourself, of course. When Jack and I met, he provided me with an inventory of assets or a list of everything that he had. So this includes for all of us, any and everything that you have, real property, of course, bank accounts, investments, retirement accounts, life insurance, all of those things comprise or make up your estate. And some people will say, well, I have a couple of bank accounts at Wells Fargo or, Bank of America, but they're only $100. So I don't really have that much at those places. How you should think about it is you want to be sure that every single last penny is accounted for and that it's streamlined into the trust, or dealt with beneficiaries, meaning that if we have an account that has $100 in it and it's not in the trust and there's no beneficiary designated, then somebody has to prove who that goes to. So it's important that every single thing you have be considered and included when you talk to your attorney about setting up this estate plan, so that we can make sure that those small accounts even are listed in the trust as well. So when I met with Jack, we talked about the fact that he owned a house and was living in a house in Orinda, that he had several other properties in the state that he used as rentals. Of course, we went through his bank accounts and his investments, retirement, and we even reviewed the things or the stuff he has in the house, because again, back to the probate conversation, when you have assets over $160,000, those assets, that's the threshold which triggers a probate for your estate. So if you have a couple of really expensive cars or a art collection, things of that nature, that can push your estate into probate. So we really want to review, in addition to the real property, in addition to money, in addition to cash assets, that even the stuff in your home might be something that's really valuable, or you might feel really strongly about some sort of family heirlooms or things that you acquired over your lifetime that it's really important to you that it goes to a specific person. So those are all the things that Jack and I reviewed at our meeting and that I talked with him about as far as figuring out, okay, who's going to get what, who's going to be in charge, and how is this going to go? So one of the things that I do when I meet with clients is pull up deeds to their property or properties, because we want to see, what does the current deed say? People will buy a house, of course, in their names or in their name with their partner, or they'll inherit it from a family member. And they might think, well, now it's mine, but they might have done a refinance along the way. They might have added a child on. They might have received it from a parent and not made changes. So those things are all really important for me to do as the attorney to review. And in this case, when reviewing the deeds, I found out and discovered that Jack's father, Jack Sr., who had since died, was in fact the owner of the Orinda property where Jack was living. So Jack inherited that property from his father, but he never did anything to actually move the title into his name. So Jack Sr. is still listed on the deed of the Orinda property, and its estimated value at that time was $1.7 million. So since Jack Sr. had died, then I told Jack, my client, that this means a probate's required. Jack Sr. didn't have a trust set up. Obviously, $1.7 million is well over that $160,000 threshold. And so that meant that Jack now has to open a probate in court to get his dad's house moved into his name. In Contra Costa County, which typically is probably the quickest moving of all the counties around here, a probate is taking at minimum 12 months, probably 12 to 18 months is most accurate, and can even take up to or over 2 years right now. And especially since COVID took place and coronavirus was spreading all around, the courts were delayed. And so a lot of the probates in 2019 and 2020 have all got pushed into 2021 and 2022. So, we're working on a really delayed timeline in general with probate, but especially now with COVID and how inefficient things are moving along. So again, when you remember, I met with Jack in February, and he's expected to live for a few more months. So certainly he's not, like, it's unlikely that he's going to live the 12 to 18 months to carry out the probate, but we know it's something that's going to be moved into his estate upon his death. So Jack, as the surviving son of Jack Sr., decides to nominate his daughter Sally as the administrator of the estate. So again, Jack would have been the administrator, but because he's not going to be well and able to take care of it, he can nominate who he'd rather serve in his place. And he chooses his daughter Sally to be the administrator. So we filed the probate petition on Jack Sr.'s estate in March. Remember, I met with him in February. We filed the probate in March. And in the meantime, Jack and I worked to complete his estate plan, which includes setting up the trust to house all those real properties and the assets, creating a will, which is a safety net or a document that falls underneath the trust. Is called a pour over will, because it basically catches whatever you forgot or didn't list in your trust and moves it into the trust or pours it over into the trust. Also, we always, of course, want to have a power of attorney for both medical decisions and financial decisions. So if Jack were to lose capacity, during the rest of his life, then he wanted Sally to be able to make decisions for him. And then we had to do quit claim deeds for his property. So not the Orinda property, which is in the probate but for his other rental properties, we moved them from his name as an individual into his trust. And those are all things set up in March.
This could be of interest to you.
Sorry? Did someone have a question or no? No? Okay. If you do, let me know. So we completed his estate plan in March. We went in February. We rushed things along. We worked as quickly as we could in order to get things set up for him, to give him that peace of mind, so that as he approached the end of life, he didn't have to think about this. At least he knew that he was taking care of what mattered to him, which was the two kids in this case. And then unfortunately, or sadly, and as expected, Jack passed away in May of that year. So the question now is, did Jack fund his trust, or what might have to go through a probate? Because we set up the trust and he has all these assets. And so when you set up a trust, you need to actually move assets into that trust. Lots of times people don't complete that process. The attorney can do portions of it, but a lot of it has to also be done by the client. So I mentioned that we moved his real properties into the trust. That funded or set up the trust. We know the real properties are safe. He had several bank accounts. So Jack set up his Chase and Morgan Stanley accounts with the trust. He retitled them actually in the name of the trust. And so that avoids the probate. That means that on his death, Sally, as the trustee, has authority now over managing the Chase accounts, the Morgan Stanley accounts, and those real properties because she's a trustee. So she can start using that money to pay off his expenses, to pay for his funeral, to deal with his medical bills. And then if she needs money to pay herself or pay a lawyer, deal with taxes, she has readily available access to those funds for his needs or for the expenses of Jack's estate. Unfortunately, Jack did have a Wells Fargo checking account that had a $450,000 balance in it. And again, that's well over that $160,000. So there's no beneficiary named on the account. There's no payee on death. It wasn't a joint account with Jack and Sally or any of his other kids. And it wasn't titled into trust. I didn't have any notes about it. And so I had no proof to show that he intended this to be in the trust. So this means that we were forced to go to court, to the probate court, and deal with how we were going to get this moved over into his trust. Luckily, as I mentioned to you, we have a pour over will. The pour over will catches that asset. And so it says anything that I have that isn't listed in my trust, I want it to be transferred or moved to my trust. So again, even though it's not ideal, at least the will still directs the court what Jack wanted to happen with his assets. So we were able to move the Wells Fargo checking account into the trust eventually to be sure it's distributed under the terms that he wanted. I mentioned I recorded the quitclaim deeds transferring his real properties to the trust other than the Orinda house. So that avoided probate on those. Unfortunately, as we talked about, the Orinda residence is still in Jack Sr.'s estate. So we're dealing with a probate for Jack Sr. But the good news is we were able to avoid a subsequent probate for Jack because I knew that Jack was dealing with this. We discovered this when we first met. So as his attorney, I prepared what's called an assignment, which assigns all of his interests to his trust. So one of the things that we assigned was his interest in Jack Sr.'s estate and specifically this property. And then within the trust, you have a schedule where it lists all of your assets as far as here's my houses, here's my bank accounts, here's my investments, insurance. So one of the things we listed was his interest in his dad's estate and his interest in the Orinda property. So what we then do is, unfortunately, again, we have to go to court again, but we file a petition with the probate court called a Hegstad petition or an 850 petition, which essentially asks the court to confirm what Jack's intent was, those properties get moved into the trust. So as you can see, there's a lot of different moving parts that you have to think of when you're doing estate planning. And it's kind of this puzzle that fits together, anticipating, well, if this situation happens, then I need an assignment. If this situation happens, I need the trust schedule. If this happens, I need the will. So you want all these pieces to fit together to ensure that no matter what happens, you're eventually going to get everything to the trust and that the trust is going to be distributed the way that the person wanted, as opposed to the intestate rules, which would just go naturally to children or grandchildren or blood relatives. It may not be what Jack wanted. And then on his retirement accounts, he named Sally and Daniel, his two kids from his marriage to Lenore. So when there's a payee on death or beneficiary designated, that avoids the whole trust and probate process entirely, and it's just paid to those people directly. They submit claim forms to the retirement company. And usually most people will have beneficiaries listed on their retirement accounts. You only want to list beneficiaries on a retirement account, or excuse me, a trust as the beneficiary on a retirement account when you're dealing with young children who are under 18 and you want it managed for longer in their life, or if you have some sort of charitable donations that you're dealing with or special needs type of beneficiaries. So this, does anybody have any questions? Well, is there anything I can answer for anybody, or is everybody following along okay?
Cindy, I was just going to make a comment. This is quite the soap opera. It's, I'm leaning in like I'm watching TV. It's yeah. Amazing.
Okay, good. Very exciting. I mean, it's amusing and entertaining to think about, but it's real life, right? People deal with this stuff all the time. So as you can see here, I'm kind of making a joke of Jack, a tale of two probates, because we're dealing with these two separate cases for two separate but related Jacks. So probate number one, as you recall, we started early on for Jack Sr.'s Orinda property, and Jack Jr. nominated Sally to take care of that probate. So as I said, we filed that in the end of February or beginning of March. I think it was March actually. And that probate has moved along now. So just to give you a sense of just timing and fees, to simply move a property into a trust, basically, but through a probate here, it's taking 12 to 18 months, or really it's up to 2 years at this time for the court case to go through. You're spending $3,000 in filing fees, appraisal fees, certified copy fees, court fees, publishing fees, things that just go on and on, because these are all the things that are required as part of a probate. So those are just the fees alone. Then you're paying the attorney's fees and the administrator fees. So in this case, or actually for probates in general, you're paying a percentage of the, your fees are based on the percentages of the value of the estate. So for a probate that is $1.7 million, the attorney's fees are $30,000. If Jack Sr. had set up a trust where he had moved this property into his trust earlier in his life, it would have been a few $1,000s. So instead of spending, $3,000, the estate's spending $30,000+ on the attorney's fees alone, not to mention the filing fees. In addition, the administrator, the person who's going to court, who's the client, also is paid the same amount of fees as the attorney is. They can choose not to be paid those fees, but in this case, Sally said, hey, I'm doing all this work. I'm going to court. I have to work with this attorney. I have to get the house cleaned out and sold. I have to do all these things, and I want to be paid. So not only does Cindy, did I get paid $30,000, Sally's being paid $30,000. Plus our $3,000. So that's over $63,000 now that it's costing Jack Sr.'s estate just to move that property into Jack Jr.'s name. All right. Then we have this simultaneous, so to speak, probate going on for Jack Jr. And this one is not going to be as complex and as drawn out because we have these things that I did to plan and prepare for this to happen and anticipating this happening. So remember, we have that Wells Fargo account and we have the interest in Jack Sr.'s estate that Jack Jr. would have been inheriting. And so as you might remember, I said, we prepared an assignment assigning Jack's interest in his dad's estate, assigning these things to his trust and listing them in the trust schedule. Plus we have the will showing that everything that Jack Jr. has that wasn't in the trust should be moved into the trust. So this is going to take us 6 to 8 months probably, and is going to be another several $1,000s in filing fees and certified copies, not as extreme as the full probate, but certainly expensive. And then another $4,000 in attorney's fees at best, if not more, because of delays and complications. So the probates now are costing approximately $67,000, whereas Jack Jr.'s trust that he set up cost him $3,000. And had Jack Sr. set his trust up back in 1970, it probably would have cost $600. So you can see how expensive the probates get and how long they are drawn out. You're spending years now in court to deal with this. To make things more interesting, we have the tale of the forgotten son, Jeffrey, who Jack met as an adult. So Jeffrey, as you might remember, was not raised by Jack. They had no relationship. As I mentioned, I don't know if Jack even knew about Jeffrey, but Jeffrey, as an adult, he reached out to Jack and they connected. And so I knew about the relationship as an adult, and it was important for me to write about Jeffrey within the estate plan, because had I not listed Jeffrey as a child, then he would have had a 100% 1/3 automatic claim to the estate because of there being 3 children. Now, Jack didn't want to leave a third or anything specifically to Jeffrey. He didn't have that kind of a relationship with Jeffrey. He had long-term relationships with his two children who he raised and knew, and he connected with Jeffrey, but there was no intent on his part to financially plan or prepare for Jeffrey. So Jeffrey sues the estate now and claims that he has an interest in both his dad's trust, the potential probate that we're dealing with for his dad, and under his grandfather, Jack Sr.'s estate. So he's trying to make a claim that Sally, the administrator and trustee for Jack, and also Jeffrey's half sibling, that she influenced Jack, and she and Daniel essentially worked together against Jeffrey and basically were jealous of the relationship that he and Jack created. And so he believes, or tried to say, that Sally forced her dad to leave everything to Sally and Daniel, that Sally forced her way in as the administrator and the trustee, and that she used that influence to overpower Jack and force him into doing things that he would not have done. Jeffrey feels that his dad promised him that he was going to get the Orinda house, and that Jack promised Jeffrey that house out of guilt for not being involved in his childhood and not having any sort of a relationship with him. And that he said, my dad promised me the Orinda house. This was how he made it up to me, that we had no relationship when I was a child. And so the question is this true? Because there's case law on the ability to create a will by oral contract. And what that means is, if I, as a person, go around and tell a bunch of people, well, I'm planning on leaving my house to Jack, and I'm meeting with an estate planning attorney, and hey, Jack, I promise you I'm leaving you this house, and there's enough proof that's out there that that was my intent and my wishes, then people can actually be held accountable for creating a will or trust by oral contract. And as you know, most deeds and trusts and wills and whatnot are all written and really have to be written. But sometimes in certain situations that might not take place. And so the contract law says if somebody relied on the promise you made to them and it's affecting them to a detriment, that they can rely on that and actually seek damages or remedies for that oral contract you made. So in this case, that's what Jeffrey's trying to say, that, you know, my dad meant to leave his house for me, and he may not have followed through, but he promised it to me, and I'm going to sue the estate because what you put together in this trust, it was only a product of undue influence, or Sally, you know, using her weight and pushing dad around. So if this is the case, I as the attorney can't represent the estate or Sally anymore, because now I'm a witness in this lawsuit because I was a drafting attorney for Jack. So often if when someone passes away, if there's a conflict between the family about the trust and how it's being distributed, I will be asked to be a witness, and which means I have to attend a deposition and testify about what the person told me as far as what their intent was in putting their estate plan together. It's, you know, stressful and uncomfortable. No one wants to go through that, but my duty is to speak on behalf of the person who passed away, because of course they cannot speak for themselves, and my notes have to explain exactly what the person wanted. And so I'll ask people really uncomfortable personal questions if there's not a totally natural distribution going on, because I really want to be able to explain why they chose to not provide for this child, or why they are giving different amounts to different family members and whatnot. So my job is to speak about the intent. But if an attorney is going to be a witness in a trust administration or a dispute, then they can't continue to represent the trustee. So you can understand that in this case, I said, well, I'm going to have to resign. I can't represent you anymore because I have to be a witness for your dad. However, we had something that worked out really well in our case. We had the receipts. What does this mean? This means that when I became the lawyer for the trust, so for Sally, we had to send out what the trust said and send what's called a required 1606 1.7 notice, which essentially says, you are a beneficiary under this trust. Here's all the information that pertains to you. Here's who's in charge. And you have 120 days to contest this trust. So when we send that out, We want to make sure that the person in fact receives it and that they know that that 120-day clock has started ticking. You as a trustee have to send this out within 60 days, and then they have 120 days to object to it. So we had the receipts. What does that mean? We sent Jeffrey the copy of the trust, and he had 120 days to object to what the trust said, which did not include the house and Arenda going to him. Jeffrey filed his lawsuit 127 days after being served with a copy of the trust. So he was 7 days late in lodging his lawsuit against his dad's estate and his half siblings. So fortunately for myself and for everybody else, we kept receipts and proof of that, showing that Jeffrey in fact signed for his FedEx package containing the copy of the trust, and that he knew the terms of the trust well in advance, and he chose not to file his lawsuit. So he was unable to contest, to make the argument that Sally had actually used undue influence. There was no argument for him to make anymore. He had no facts. I had no notes to prove what he said. There was nothing that I had that said that Jack wanted his house to go to Jeffrey. Everything I had said that it was going to Daniel and Sally. So the case is going to be dismissed. Hopefully, I say, because you're still dealing with negotiations with people. People still try to figure out ways to get in and ways to lodge a claim against the trust. And, sometimes we might advise the person, the trustee, to give some money to the person or try to make some sort of offer and goodwill to help things go away. So we're still working all of that out and negotiating those things. So what is the point of me telling you this story? That estate planning is really critical. It can save your family a huge headache. It can save your family lots of time, and it can save your family lots of money. In this case, Jack did estate planning. He found out he was going to die, and he took his final wishes really seriously. He prioritized seeing me and making what he wanted done clear to me. The thing to think about, especially if you have conflict in your family, or if you're doing something where you're worried about how it's going to be perceived, you're not going to be here to answer questions. You cannot run interference between your kids anymore. You can't explain, why you chose to give something to this sister and not that sister. You're not here to answer the questions. So the more transparent you can be with your attorney and your family about what your wishes are, the better things are going to go when the estate starts to be administered and the funds are distributed. It is worth it to spend the money now and cough up the several $1,000s to get your estate plan in place, so that your wishes and what you want will be fulfilled, as opposed to all of your family business and private matters going through the court system over a several year period of time and costing tens of thousands of dollars. It's just not worth it. It's expensive, it's time consuming, and setting up your trust can avoid a lot of this. And I think I just want to go back to my point also, in this case, Jack did set up a trust and he did make his wishes known, and his family still had to go to court and spend money on things. So it's really important to continually think about what's going on in my family. What are the changes? Am I buying a new house? Is someone in my family been divorced? Has someone died that I originally listed? Am I acquiring new assets? Am I doing a refinance? Have I inherited things? You should check in with your attorney routinely, even if it's a quick email just saying, hey, I'm doing this. Does this impact my estate plan? Because the laws change, your facts change, and the trusts are set up so that you can make changes as needed anytime that they're present. A revocable trust is just that. You can revoke it or amend it or make changes anytime. And you're making decisions on facts that you know today and what works for you today. But in 5 years or 10 years, facts might change, relationships change, assets change. So those are all things that you want to consider when you're updating your estate plan and getting things in place and hopefully streamlining it for your family. So it's really a gift that you're putting together for your family and making sure what you want to happen with your assets are taken care of. So I'm just about at the end of my time, and I'm glad to talk about more details or share more information if anyone has any questions. Is there anything I can go back to or that anybody has questions on? Let me stop my share screen so I can see everybody here. Okay, there we are. Okay, so I don't know how to unmute people. Do I ask people to unmute, or is Barbara? Go ahead, Barbara.
I can help with that too.
Yeah, I know how to do that. I just want to say that was a very good presentation. I have a trust and an attorney, and I have made some changes since I originally made the trust. And it's a good reminder that even if you have trust, that it may not always be up to date with your wishes. You might want to increase numbers here and there, charitable or otherwise. So yeah, that I thought it was a very good presentation and understandable and well thought out. And thank you for that.
Thank you, Barbara. Yeah, I think that what you just said is a really good point. A lot of people set up a trust in, the 1990s, and lots of things have changed since that time, not only with you and your family and what you might own and not own anymore, but also the laws have changed a lot. And there have been really significant changes in the laws past 2010 as it pertains to tax exemptions. And there is a really important case that took place in 2016, which allowed attorneys to have a little bit more leniency in showing the intent for clients so that we're more easily able to move assets into their trusts so that they can avoid the probate. And so you might have a trust set up in 1990 that says, well, everything I have goes to my partner and then to my 2 kids. But there are different structures that were appropriate in the 1990s for a trust that are no longer appropriate now. So even if nothing has changed with your children, there are still tax laws and other things that you want to think about that could impact your estate and cost or save your family money depending on the structure. So yes, you're very right that it's great to have one set up, and it's a really good idea to check in with your attorney and just say, hey, it's been 5 years, 3 years, 10 years since we've touched base. Can we just go through my estate plan to see if there's anything new I need to be considering? So thanks for your comment, Barbara.
Yeah, you're welcome. There's so many different situations, and just since I made mine, and I can't even remember what year I made it in, but people that were going to inherit have died. And in fact, my younger sister predeceased me, which was not expected, and so on and so forth. So a lot of different things to think about with all of it.
Yeah, that's exactly right too. And that's something else that you want to think about with the estate plan as well. These people are all most likely to die after me, but what if they happen to die before me? I need to build into my estate plan. If anything happens to my sister, who's going to receive everything? Is it going to be her kids? Is it going to be my other siblings? Is it going to be charity? Is it going to be, CSC? Who's going to get my money? You want to think about all of those things and plan for all these. Well, that might not happen, but what if? Yeah.
Yeah.
Okay. Does anyone else have any questions or comments?
Yes, I do.
Please go ahead.
I'm Bill.
Hi, Bill.
Yeah, I do have a trust. And I think it's in good order.
Great.
But after listening to you, I'm not sure. But I'll check out.
Oh no.
Yes, you have me doubting. But in the meantime, my main question has to do with a letter that accompanies the trust, distributing things that are not included in the trust, or they're not qualified to be in the trust. I've heard about this many times. How do you deal with that? And what does it hold any weight?
So
how much weight does it hold?
It's I'm not sure if I heard you. It's a company who's writing a letter about distributing something.
No, it's me.
Oh, you're writing a letter about things.
I'm writing a letter of instructions.
Oh yeah.
For things that are not included in the trust.
Yes. So that absolutely holds weight. So lots of times what I'll tell clients to do and this pertains to both the trust and other items outside of the trust. First of all, it's really helpful if you can write a letter to your trustee providing guidance about certain assets that you have, or what you envision for how things to be distributed. So for example, if somebody has a minor child, they might say, write a letter of saying, we really hope that you can keep our children in our family home until they're old enough to move out and the trust can pay for things, or things of that nature. Or, so-and-so's living in my rental property and I want them to be able to have 6 months to stay there if they can, and et cetera. But lots of times there will be things outside of the trust, and this might be what you're mentioning, as far as, my family's inherited bedroom set. This goes to so-and-so. That's not something sometimes that people include. Or I have wishes about who's going to be, so-and-so is going to work with this professional, or they're going to do this with my dog, or I want these things to be done with my house, or with my burial, those types of things. You might have other wishes that are outside of an actual trust administration. And it's really helpful to provide that information to the responsible parties. With stuff specifically, it's really advisable to do what's called a codicil, where you're essentially saying, my will is still valid, all the terms of my will are still valid, but these specific people, I want to receive these specific items. So that the person who's in charge has this letter, the executor, and says, okay, well, I know that everything's going to their kids, but this car is going to go to nephew, and the dog's going to go to so-and-so, and my kitchen set's going to my neighbor next door. So within a codicil, the way that those are really effective is if they're all in your own handwriting. Okay, all those material terms need to be handwritten, and it needs to be signed and dated. It's really, really important that it's signed and dated in order for it to be valid. If you have a family where there's not going to be any conflict and nobody cares, fine, it doesn't really matter. But if there's any concern about the validity, it's really important to have it in your own handwriting, to have it signed, and to have it dated. And you can always share. I always ask my clients to share all that information with me, even just little notes that they leave as far as who's going to get what, because those are things that I can save in their file as their attorney. And I can also make the judgment call about whether or not we need to do something more formal beyond that letter. But if I have that proof and those notes in my file, then that's something I can do to help along the way when someone's dealing with questions that come up about the estate.
Mm-hmm. And is that called a codicil?
Yes.
Okay.
Yeah, good question.
Good. Mm-hmm.
Cindy, I think you bring up a really good point about how the laws change. So even if one's assets haven't really changed much, everybody needs to update their plans. We might have some people on the call who have pretty complicated estate plans, and some that are pretty straightforward. But is there like a uniform number of years that one shouldn't let go by before they update their?
Yeah, so it used to be pretty boilerplate or standard to recommend a check-in every 5 years. We've started saying every 3 to 5 years, just because of changes especially the last few years, just because there's been a lot of discussion about tax laws changing. When Donald Trump came into office, the tax exemption was moved up or increased from just under $6 million to almost $11 million per person. So that's a significant change that impacted a lot of people's trust designs. But that tax, that exemption amount is expected to, or is supposed to sunset in 2026 and go back down to what would have continued to climb at regular cost of living and inflation rates and whatnot. However, there's always discussion, certainly in the federal government, but especially in California, about really lowering that threshold. And so a year ago, there was a bill floating around in Sacramento to make the exemption $3 million per person. So for a lot of people in the Bay Area, especially who own your home, that puts you really close to that number right away. It's really, it could really impact a lot of us here. So that's really why you always want to keep in touch with your attorney and check in more and just say, hey, is there anything I need to think about with my estate planning with these laws? Is there laws that are changing? Or another really good example in this last year is so many people have been refinancing their homes because of these low interest rates that were going on. And because of that, I think overwhelming volume, a lot of the title companies didn't move the houses back into the trust when the refi closed, or they won't do it because of liability reasons. And so I've had to deal with a lot of that for folks too, of basically trying to figure out how we can prove their intent was that it was be part of the trust. They just simply took it out for the refi. So really, you know, it should be every 3 to 5 years you're checking in, but anytime there's a change or anything you're doing with your finances, it's a good time to just run it by your attorney with a quick phone call or email. And someone else had their hand raised, but I think I don't see. Oh, Mary, it says MacBook as Mary, right?
Yeah, I don't know why that doesn't usually happen, but it did today.
Okay.
We had our trust done 2 years ago, and I had an expectation of an award from the federal government for some issue that I don't want to go into.
Okay.
But I didn't have it yet, so my attorney put in bank account which holds the award from, and then I set up a bank account and a savings account, and I would like to actually put the number of that savings account on my property list at the end of the trust.
Mm-hmm.
Do I have to actually have the trust amended to do that, or can I write it in pen or?
Yeah, so that's really good. That's a perfect example of what we talked about in my fact scenario, where a lawyer is anticipating that money coming in. And so rather than that award money potentially going through probate, it's already going to be caught by the trust. So that's great. And I think that it sounds like your attorney made it pretty specific because it talks about where the bank account is, correct? Or
no.
Just a bank account with award money?
Yeah, essentially that.
Yeah, so you should never write on your trust because it's not proper and it can invalidate things. So that's not a good idea. But this is a good example, kind of what Bill had mentioned, of where you could just put something together with your, just to give some notes and information. So you might just write up a piece of paper that says, I am expecting, you know, XYZ award from such and such. And
well, I actually have it now.
Oh, okay.
So I have it in a bank account.
Yeah. So what we do, and you can even just send this as a question for your attorney that I would think they'd be willing to ask without charging you, but I don't know. But we send a blank schedule to our clients to basically notate. So you have a trust schedule, like the one you just referenced, and we send a blank one, and the clients keep notes on there of things that they add to the trust. That is a proper and appropriate. So what you might do is consider doing something like that, where you're just making notes and keeping that with your copy of the trust to provide more information. Now, is that bank account in the name of your trust?
You know, that's my other question. I need to go find that out.
I would do that. And that's really the best thing you can do, is get that account linked up with your trust.
At the time I made it, my husband was in a wheelchair, and getting him to the bank was just about impossible.
Yeah.
And they wouldn't do it without his signature.
Right.
Even though it's my personal property.
Sure. Right. So, right. Can you get to the trust account set up now?
Yeah, I think we can.
I would do that. That would be really important to do. But since I don't know, and I should tell everybody this, I don't know any of your specific facts and whatnot. Yeah. For everyone who has an attorney, you should talk to your attorney specifically about it, just to make sure this doesn't conflict with whatever advice they've given or set up for you.
Well, she wrote that part on the
that's great.
schedule, so she was trying.
Yes, and that's exactly what she should do.
So actually make a note and then make sure the title is correct.
Yeah, really the best thing to do is to get everything that you have, like I mentioned, even that $100 checking account, linked up with the trust, whether it's in the name of the trust or the trust is the beneficiary, whatever your financial institution requires. So then you can really be sure that even if it's not listed in the trust, because things have changed, your family or whoever the trustee is knows to move that account over there because it's already set up. It's in the trust. So it's obvious that that's a trust asset.
Okay.
Yeah. Good question. Yeah, of course. Anybody else have any comments? Oh, Nancy.
Hi. I've got a question. I have a trust. It's pretty simple, pretty round. But I wonder if you could address another issue, which we haven't talked about, which I have from a large family and have a lot of good friends that have money, and they all are asking me, a lot of people are asking me to be their executor. I'm like,
sure.
well, a second, what would, and I've said yes to a couple, but I'm like, could you just give a short vision of what I've never done it? What would that entail? And how big of an ask is that asking me? And I know I do have the right to say no, and there should be a secondary one on the document.
Right.
But I just have never done it. I don't want to be, I don't want to spend all my life doing everybody else's, especially based upon your presentation. Yeah, I don't want to get involved in the weeds on a net.
Yeah. So that's a really good question, Nancy. The great news is you can get paid for being the trustee. You can make good money on it and you can be compensated for it. That's the only good news about being a trustee.
Yeah. That's not really, I don't really need to be.
You don't need the money, right? So being a trustee is a huge ask. It is extremely time consuming and it can be very stressful. It really depends on the family, the assets, and whatever those facts are. But even for a very simple trust administration where, there's just, you're selling a house and liquidating a couple of bank accounts and distributing it to 2 kids or something, you're still dealing with a lot of logistics and dealing with waiting around for a bunch of time periods. So you as the trustee are held to this standard of being a fiduciary, which is a legally responsible role to meet certain requirements. And if you don't follow those rules, you can get yourself in trouble. So you definitely want to hire a lawyer. You definitely want to hire an accountant to make sure you're doing all your legal obligations and filing the taxes and whatnot properly as a fiduciary. But there's a bunch of timelines you're waiting on. So in theory, it should be really simple. Okay, I'm the trustee. I'm taking charge of these assets. I'm selling things. I'm liquidating things, and I'm distributing to the 2 kids. The end. Unfortunately, it's not that quick. And so that's more of what I mean by the big ask, because there's a lot of waiting around because of these time periods. And even if you do distribute sooner than later, you're still going into the next year because of tax returns. So this is assuming there's no problems, of course. A lot of the times what may happen when someone passes away is conflict and things come up out of nowhere. People might have gotten along during their lives and then the parent dies or money comes out on the table and it creates conflict and hurt feelings about things. I had a brother and sister who spent 6 months fighting over a painting that sat in my office for 6 months, and they wasted a bunch of money on it. And eventually it went to one of them, and the painting itself ended up in the trash bin in my parking lot. So they spent thousands of dollars fighting over it, and they didn't really care about the painting. They just wanted to hurt each other, right? And so that's the thing that I would ask the people who are asking you to be the trustee to try to understand, can you tell me more about your wishes? Can you tell me more about your kids? Can you tell me about what you want to happen? And try to get a sense of what the conflict will be like. Hopefully there will be none. It might be a very sweet, easy situation where it's kind of a headache because you're dealing with the logistics, but you're not going to have to deal with personalities and conflict. But for me, as the estate planner, those are all the questions I ask because I really want to understand what's going on and make sure that people get along. And if they don't, I need to know why so that I can anticipate what's ahead. And so you as the trustee just want to ideally go in with your eyes wide open, knowing what as best as you can, know what to expect. And then definitely, as you mentioned, there should be in all the trusts where you're being designated, they should give you the opportunity to decline to act or resign and someone else listed after you, because you might start the trust administration and then people don't get along or are fighting and you might want to say, this is too much for me. I'm not going to get involved in this.
Yeah, absolutely. Yeah. Okay.
A lot of record keeping and a lot of just managing and micromanaging and things like that. So if you're a really organized person and really good at those things and can get things done, that's probably why people are asking you, because they trust you and know that you will take care of things and won't get emotional. And so I just would want to be prepared for if there's going to be any sort of issues along the way, but it is a big job.
And for a few people that they don't have any errors.
Yeah.
That's just pretty much what they've designated then in their trust. So those would be the easy, right?
Yeah, right. In theory, those should be the easier ones. So I can tell you, I have one going to a couple of charities right now, and the charities have many more questions than other people do and want to make sure not because they're being greedy, but they want to make sure they're not getting, you know, losing out on a single penny. And so they're making the trustee jump through all these hoops to provide all these records and do extra steps. So you just never know.
Thank you. That's good to hear.
Yeah, thank you, Nancy. Anybody else?
This really has been a really interesting and really informative presentation. Thank you very much, Cindy. We really
Thanks
appreciate
for having
it.
me, you guys, and for all the good questions and interest. And you know, it's important to think about these things. I know nobody wants to talk about it and think about it, but once you get past the discomfort of it all, the more you can kind of get comfortable in the discomfort, the easier it is to make decisions and just, you know, move along and take care of things. So thank you so much for having me.
Something you just said about charities and getting involved. I have designated some organizations as the beneficiaries of my IRA.
Sure.
Is that going to cause anybody in my family any trouble?
Is your, and I wasn't sure from what you said earlier, do you still have a spouse?
Yes.
Okay,
yes,
so
he's a second, we have separate children.
Also. Huh? He's on there also, you're saying?
No, on one IRA goes to my daughter and some charities.
That's not his daughter, you mean?
No.
Okay. So there's a couple of things just, and I don't, that's a really specific question. So just to give you a general answer, generally speaking, it's great to leave charities as beneficiaries for retirement assets because they're not hit with any of the tax consequences that the rest of us would be if we were to receive a retirement account. When you're married and if you acquire the property during marriage or retirement account during marriage, typically the spouse has to be listed first. So your spouse would have to sign off on that, but I don't know anything about your retirement account. So again, that's a really unique question that you might want to, that would be something I would recommend that you just run by your attorney to make sure that it's not going to create any sort of problems.
I have two IRAs and he's the beneficiary of the second one that was came after we were married.
Okay, so the other one was separate property. You had it prior to marriage.
Yeah.
Yeah, so that should be okay, generally speaking again, but yes, it's usually fine since it's a personal property or a separate property prior to marriage to have your child listed and then to, or shared with a charity and whatnot. That's very reasonable, yeah. Okay, well, if anyone thinks of anything else or has any questions, feel free to reach out to me. I'm glad to touch base with you. And for all of you who have your estate plan set up, we just want to remind you it's a really good idea to touch base with your attorney as well to make sure that everything's planned for you.
Thank you,
Cindy.
Thank you very much, Cindy. One last thing, I just want to say that, Cindy, thank you for this presentation, but also for serving on our Legacy Advisory Council. We created it just to be such a valuable resource for our members. These are really helpful. So if anybody on the call wants to connect more with anybody on the Legacy Advisory Council, you can reach out to Libby or me. These spotlight really what we're trying to do, and I hope you guys can join us for the next two in June and July. But thank you very much, Cindy.
Yes, thanks, Andy. Thanks, Libby.
It was excellent.
Thank you so much. All right, everybody, have a great day.
Thank you.
All right, bye-bye.